Thank you, Mr. Chief Justice, and may it please the court. As a result of the assault, which Mr. Dwight pled no contest to, Connor Richards suffered serious injuries to his teeth and to his gums, which required about $23,000, almost $24,000 worth of surgeries to repair. Thankfully for Mr. Richards, his father, Michael, was of means enough to pay to have that surgery done. And so Connor Richards endured no monetary loss, no property loss, because his father paid the bill for him. As a result of that, Mr. Richards, Connor Richards, was not entitled to collect restitution.
So if he'd gotten the money from his father, but the father says this is a loan so that you can pay your bills off, then it's recoverable?
It would be recoverable as a monetary loss, certainly, because at that point he's in debt and he's got to pay that back. But under the facts that we have here, Mr. Richards, Connor Richards, incurred no loss here. His father fronted him the money, and under the facts as we understand them from below, he's under no obligation to pay that money back.
Did the defendant, I'm sorry, did the defendant pay something to the Vermont Restitution Unit, and what was that for?
The Vermont Restitution Unit, I fronted about $2,100, and
Was it also for the repair of his teeth?
yes, and I think insurance covered a piece of this, but not all of it, so there was some recovery there.
Okay.
There was no contest as to that $2,100 that the restitution unit, but the remainder of this is about $21,000 that Michael Richards paid on his son's behalf.
Right, but doesn't the statute talk about uninsured and insured losses? And
Yes.
aren't you essentially trying to make the father an insurance company?
Well, no, we're focusing on the word loss.
Well, who had the loss here?
Well, nobody had a loss here, at least not one that's compensable.
Who was responsible for the debt?
Ultimately, Michael Richards, the father, is responsible for that credit card debt that he's going to pay as a result of this.
Yeah, whose bills were paid with the credit card?
He paid Connor Richards, his son's bills with the credit card.
Right, and the son's bills were a direct result of the incident?
They were not medically necessary, for one. These were bills to cover something that the insurance wouldn't cover because they were not medically necessary for his recovery. Surgeries to repair the gums and I think
That's not medically necessary?
That's, the insurance did not determine that to be medically necessary, Your Honor. And so in order for Connor Richards to have his teeth back, he had to go through these surgeries, and his father, instead of requiring him to pay the bill, put $21,000 on his credit cards in order to have that done.
What was the evidence that I read about his father saying, I'll pay for your teeth, but that means I can't pay for your college?
Apparently, the father and the son had an arrangement where Connor was going to have his tuition paid at UVM. And his father said, you can either have your teeth or your college.
So why can't we consider that his money then, right?
So-
It was earmarked for him.
Right.
Father intended to give it to him. Why is that not Connor's money?
We recently, in Justice Eaton's opinion in Baker, we talked about the direct result part of requirement in our restitution statute. In order to be compensable under our restitution statute, a loss has to be the direct result of the crime. Now that incorporates a proximate cause standard, which is a reasonable foreseeability standard under Baker. It is not reasonably foreseeable that somebody would have to forego a gift as the result of a simple assault, which is what would happen in this case. There was some money available to him to go to college, and he had to forego the tuition reimbursement that his father would have given him in order to have the teeth repaired.
So I'm puzzled by this whole discussion about who paid and who owes what in college. When I look at the statute, it says you can order restitution for damage or injury, but then it goes on and says it's to be awarded in accordance with Section 7043. Section 7043 says you get restitution for a material loss. Then goes on to define material loss as including uninsured medical expenses. Why doesn't that solve the issue. It doesn't say unreimbursed, uncompensated, medical expenses that haven't been paid by someone. It says uninsured medical expenses. This is an uninsured medical expense, whether or not dad has paid it. Why isn't that the end of the conversation?
With respect, Your Honor, I would disagree with you for exactly the reasons that we discussed with Justice Skoglund. This was not medically necessary, so I'm not sure that this qualifies as a medical expense. But second, each one of these, it's...
It was not medically necessary within the terms of his insurance policy, which is why it was uninsured.
Right, and I don't think there was any testimony from Connor Richards, who was the witness on this issue, that this was medically necessary for him to continue.
Did the trial court make a finding that this wasn't medically necessary?
I don't think that the trial court made a finding under under any one of those three exactly. And I don't think there was any testimony from a doctor or from Mr. Richards to say this was medically necessary so that I can chew my food or do something. He could eat steak still, as far as I know, but there was no testimony to the contrary. But each one of these three categories that we have under the 7043, it's an uninsured property loss, a la State versus Morse, damage to a car or Baker. Uninsured out-of-pocket monetary loss, that's something that you've actually lost. An expense is an expenditure. The Black's Law Dictionary defines it as something that's an actual outlay. And there is a distinction between the civil damages area, which the restitution statute is not supposed to cover. But these are actual outlays that a person...
If uninsured medical expenses only kicked in when you actually had paid them, wouldn't it just be subsumed within uninsured out-of-pocket monetary loss? Wouldn't you not need a separate designation for medical expenses?
That's possible, Your Honor, but under this, either way, I think that what we need is some sort of either a debt that you have to pay or you've actually paid the bill. And under no scenario here was Connor Richards required to pay a bill because, thankfully, his father paid it.
He was required to pay a bill. He incurred the bills, and father gave him the money to pay it.
Respectfully, Your Honor, I think that just Judge Cruschetti made a finding on this, and it was that, and it has to do with the peculiars of dental insurance, but in order to have the work done,
Right,
he
somebody
had
had to guarantee the payment.
had to pay up front. So, with respect,
It was his teeth that were being worked on, and the debt was for working on his teeth, not the father's teeth.
but he incurred no loss as a result. It may have been his teeth, but when he had somebody else give him the money to do it, he incurred no loss. The other half,
So isn't the result of what you're advocating for applying only to financially disadvantaged victims? Because a victim who's not financially disadvantaged would have the ability to pay his or her bills and then get reimbursement from a defendant. But in this case, we have a financially disadvantaged victim, a student, who was unable to do that and had to have somebody else do that for him. And now you're saying he can't get the restitution. So aren't we really treating financially disadvantaged victims different than others?
I disagree. I think that what we're treating here is a financially able person who was able to have the resources to have somebody else come in and pay the rest of his family.
I'm talking about the person himself. Connor didn't have the money to pay this, right? If Connor did have the money to pay this and paid it,
Would have been,
he would have gotten reimbursed.
would have. But there is no evidence in this record, as far as I recall, that he could not have gotten a loan in order to have this done. And although, and this is what the restitution statute by its terms would require. The other half of this, of course, is whether the father could be a victim under this statute. And it's pretty clear that our definition of...
Is this a restitution claim by father?
it was litigated as kind of either Connor or Michael by the state below. And
Was the order for restitution to the father?
it was an order of restitution to Connor. There was some discussion below, and to the extent the court might explore that, we would put forward that he does not qualify statutorily as a victim in this case, because he is the family member of a victim, but the victim here is neither a minor, incompetent, or deceased, which is what we would require for Michael Richards to have been a victim for restitution purposes.
Can you shift, if people are okay with this, this second issue,
Yes.
where the court basically, in the ability to pay analysis, decides that it's going to impute income based on what it concludes that defendant ought to be earning and ought to be able to pay based on his education and background. Can you talk a little bit about that and what the basis for that would be?
The basis, well, the basis apparently, though, was both imputing it, he's a laborer, essentially, he earns about $14 an hour, but he wasn't working full-time. The restitution statute requires a court, when the court is considering the amount of restitution, and this is 7043E1, based upon the offender's current and reasonably foreseeable ability to pay. In this case, the court may have imputed income, but the reason why it essentially doubled this from $150 a month to $300 a month wasn't his foreseeable income, it was his ability to pay, and I expect you to be fully employed at all times. There was no evidence that he was underemployed for the reason of simply not wanting to work or anything like that. This seems to be motivated by...
Would that matter? In other words, does the restitution statute allow us to deem somebody voluntarily underemployed in the way that the child support statute does, and therefore impute income?
I don't think it does. It says his offender's current and reasonably foreseeable ability to pay. There's nothing there that requires us to impute some ability to pay that he's not paying. The courts seem to simply say, you need to get a different job or set of jobs.
So what if the guy says, you know, I'm not really into this whole work thing. And I'm just gonna stay home.
I think that we could probably say he had a reasonably foreseeable ability to pay at that point. That's simply not in this case. He was working seasonal work as a lawnmower and as a snowplow driver. It was seasonal work. It's work that's common to people of his age and educational level.
So you're saying you can impute income in certain circumstances, just not these?
Well, for one, I don't think that the court below decided it on that exactly. I think the motivation here, and the court says so, was I want to make more meaningful restitution to the victim, not deciding this on his current and reasonably foreseeable ability to pay.
Right, and
So we
you
think
suggest that that was a form of punishment, and
I do think it was a form of punishment.
the court seems to be looking at the length of time it's gonna take to pay it off if you're paying it off at this particular amount.
And Your Honor's point is well taken, because that is not in E1, the amount of time that it's going to take to pay it off. It's about the offender's ability to pay going forward. And I'll reserve.
Okay, thank you. Counsel?
Good morning.
Good morning.
Suppose Michael, that's the dad, had already given Connor his $22,000. Said, here you go, and Connor put it in a bank, I hope, or a drawer, and then he got assaulted, and then he had to spend that money to fix his teeth. So then he goes back to Michael and he says, you know that money you gave me for tuition? Sorry, it's gone, can I have some more? And his father says, sorry, fresh out, and so he has to take out a loan. Would we seriously be arguing that Connor was not out $22,000? So what difference does it make that Michael just hadn't happened to have written the check at that point? He's testified at the trial, at the hearing, that money was going to Connor, and that was accepted as credible testimony. So that means, for our purposes, it is true, it is a fact that Connor was going to receive that money. So it doesn't matter whether he had already received it, whether he had the check but hadn't cashed it yet and it was still in Michael's bank account, or whether he actually had the cash in his pocket. He had $22,000, which he then spent on repairing his teeth. The defendant says, well, a gift, that's not foreseeable. Well, I don't really see what that has to do with anything. An inheritance isn't, I mean, before you assault somebody, you have to be able to foresee what availability of funds he's got. Maybe he's going to inherit some money. Maybe he's going to win the lottery. Who could have foreseen that? Why should I have to pay that back? I also like to touch on a couple of other points. This whole bit about not medically necessary per insurance, totally irrelevant here. The statute says material loss or medical expenses. It doesn't say medically necessary is defined by insurance companies who are doing their best to pay as little as possible. It says medical expenses. And replacing your teeth when you're a young man is a medical expense. It's
So if
also,
I get my nose broken
yes,
and it doesn't functionally impair anything, but I don't like the way it looks now
Right.
because it's got a, and so I'm gonna get some plastic surgery.
right.
Is that medically necessary?
Well, if it's not medically necessary, it's certainly a material loss, because when you look in the mirror now, you're feeling a loss as to you're grieving your old looks, and
So that would be included in the
Right, you-
restitution line.
put back in the position that you were before the assault.
Do I have to show that I'm not using the opportunity to make my nose look better? Because I've never really liked my nose?
I think there could be a set-off. I mean, if the surgeon comes in and says, I touched it up a little bit, and that added a couple thousand, sure, absolutely, yeah, sure. I mean, that'd be the same if somebody crashed into my car and I had to have some things replaced, and at the same time, I took the opportunity to, have a remote starter put in. Can't charge him for that. Also, to get to this whole ability to pay thing, it's his ability to pay, not his wish to pay. And to say that seasonal work is, well, that's just something with their educational level. Well, I never heard that people with lower educational levels only work in the summer and the winter. I mean, most people work year-round. There's no reason, and the court made an observation. He said, I've seen you in court. You're a young, fit, healthy individual. There's no reason why you can't be working full-time.
What's the statutory authority? I mean, do we have any cases where we've said essentially in determining your ability to pay, we can look at your earning potential rather than your actual real-life earnings?
I'm not aware of any case that says that exactly, but I think it's obvious from the term ability to pay. What else could that mean, ability to pay? It doesn't mean, do you happen to have the cash on hand, right?
Well, it could, right? It could mean the
Well, you
cash
could
on
take that
hand and
into-
your actual
I should say it
established
doesn't-
income
It
pattern.
doesn't mean only cash on hand. It means we're gonna look at your entire life and circumstances. That's gonna include your educational level, your employment history, your current assets. What is it you're able to pay? And if,
It's interesting. So you're focusing on the educational level rather than your actual established stream of income for a period of time.
I think that if I have, let's say a PhD in rocket science and can make a lot of money, and I cause grievous injury to somebody as a result of which he's incurred substantial expenses, that is not appropriate for me to go to the court and say, well, I know that I could be earning hundreds of thousands, but actually I prefer to mow lawns and plow driveways.
So in the child support context, and there was discussion of this below, we do impute
Yes,
income sometimes,
yes,
but there's an actual statute that says we can do that.
yes.
Doesn't that suggest that in the absence of a statute that says we can do that, that ability to pay doesn't actually mean, let's try to figure out what this person ought to be earning, but is actually based on what
Okay.
they are earning?
Certainly, if the legislature used that particular language in a section of a statute and then omitted the language in another subsection of that very same section of the statute, that would be a very fair reading. Here we have two completely different contexts, statutes that were enacted at different times, and there's no reason to think that when they enacted the restitution statute, they said, well, let's not put in this specific language we used over there, because, when we say ability, we really mean, what he feels like doing, what he's in the mood to earn. And I think that the term ability itself, what does it mean, ability? He's got the ability to earn more than that. He just doesn't have the desire. So it doesn't say desire, the amount that he desires to pay. It says ability. If it means anything, it's got to mean his potential earning. And finally, I'd like to talk about whether this was imposed as punishment or not. The trial court, in my opinion, made it really clear. He was not saying, and I have the language, he wasn't saying anything about punishment. He was basically saying extensive physical damage resulting extraordinary medical bills. And this, he should work a standard work week, like everybody else, to make the restitution amount meaningful. What does he mean by meaningful? I think the defendant is suggesting meaningful in the sense of bringing home to him, you know, what a bad thing he did, sort of a punishment. But then he goes on to say, immediately after that, he says, the restitution amount proposed by the defendant would take 12 years to repay the victim. So by meaningful, it's obvious that what he means is that it's not going to be dribbled out for 12 years, that this guy has incurred this $26,000 student loan right now. He needs a stream of income to help pay that off, which he's incurred as a direct result of the defendant's punching him in the face.
Can you explain the mechanics of the fund and why the fund hasn't covered the 21,000? We're not talking about repaying the fund.
Okay, so my understanding is that, and I don't claim to be an expert on this, but when the fund started, the way it worked was they said, there's some funding sources like surcharges and so on, and they said, when somebody has, and when the defendant is a person, doesn't cover corporations or whatever, when there's a restitution order, we're going to give the victim $10,000 right up front. It has to be an order. It's not like, you know, the judge didn't find it, but we feel bad for him. It has to be a restitution order. They look for it. And I know that because I've dealt with that paperwork, and they're very sticky about it. So then, apparently, as I think everybody foresaw, that became a funding issue, and now it's been lowered to $5,000. So what will happen here is, and then the defendant's payments will first go back to repay the victim fund, and then when the $5,000 is topped off, then the payments start going to the victim. So let's say somebody's got a $10,000 restitution award. So they're gonna get $5,000 right up the top, then they have to wait until that $5,000 has been paid back to the restitution fund, and then they start getting the payments to make up the rest of it. In this case, we can't say, oh, he's gonna get his $5,000, let's not worry about it, because he doesn't get that $5,000 until he gets to the restitution order. So I hope that answers the question.
Well, but the restitution order comprises two parts, right? One is what's your material loss? And then the
Yes.
second is what's the ability to pay and therefore the payment schedule. So once
Right.
you establish the material loss,
Correct,
then he's gonna get the remaining 2,500 or whatever to get him up to the $5,000
Correct.
right off. And then he would have a gap of some period
correct.
while the payments went to the fund.
That's all correct, yes.
And then it would, okay.
Right. So the concern for the immediate concern for the victim is to get a restitution order, because then he can get that $5,000. But then we've got a $22,000 loss here, so we've still got another $17,000. And he's gonna have to wait, well, that's parceled out bit by bit, and the court's concern was, this is a big loss, so. Let's see, let me just review. I guess I just say, so the other point that Mr. Harrow made was, he could have got a loan. He could have got a loan for this. Well, he did get a loan. He got a loan. He used the money he had to pay for the teeth, and then he got a loan to make up for the loss that resulted for the student loan. And if the defendant is arguing, well, he should have gotten the loan for the teeth and not for the school, that makes as much sense as saying, well, he paid it, he had the money in his right pocket and not his left pocket. Money is money, it's fungible. And whether he uses this cash to pay the medical expenses and gets a loan for school, or whether he gets a loan for the medical expenses and pays the cash for school, makes no difference whatsoever. If there are no further questions.
Okay,
you very
thank
much.
you. How much time?
Ellen has 2 minutes and 10 seconds remaining.
Be very brief. It remains the prosecution's burden in these cases, in these restitution cases, to prove each element of what's required to make the restitution judgment order. It was the state's burden to put on evidence that he could make more money. But I would make a point here that the prosecution in this case early on agreed that $150 a month was the reasonable rate of restitution. I'm not aware that the prosecution, I could be wrong, has wavered from that point until we got onto appeal. Thank you.
Thanks very much.
The next hearing for the court is scheduled for 11 o'clock this morning.